Good afternoon, everyone. Welcome. Number 71 on the calendar, People versus Anthony Badalamenti.
Thank you. Marianne Karras for appellant, Anthony Badalamenti. May it please the Court, Mr. Richards. I want to start not at the beginning.
Counsel, before you start, would you like some rebuttal time? I'm sorry to interrupt.
No. Thank you. When the appellate division made its rulings, it specifically did not say that even if there had been an error, it would have been harmless. It didn't find overwhelming proof of guilt in this case, and that's important. When it ruled on the prosecutorial misconduct, it found that there was an error, and it found that the error was taken care of because the judge sustained an objection. But it did not say that had it not sustained the objection, there would have been it would have been harmless error because there was overwhelming proof of guilt. It did not hold that there was overwhelming proof of guilt in this case. And there clearly was an error in admitting that tape. That eavesdropping tape was error.
Which would that be for the entire case, counsel, or only some part of the case, for example, the EWC, the endangering the welfare of a child count?
I would suggest that it would be, of course, for the entire case. That there was no overwhelming proof of evidence on any point. As to the endangerment, the child's teacher testified she never saw any signs of abuse. The child's father testified that he never saw any signs of abuse. What's more, he testified that 2 days before he made the eavesdropping tape, he was hesitant to bring the child back because the child had made some statements to him. But in the very next breath, he said about my client, but I don't believe Mr. Badalamenti would have physically harmed my child. So there was certainly some suggestion that maybe the mother was abusing the child, but not Mr. Badalamenti. So yes, I would say as to the whole case. And the way that the tape was used was so prejudicial. It was prejudice that infected the whole case.
Limiting instructions that the judge gave, that it was only limited to the EWC count, you think didn't cure any problem with the rest of the case?
The count for the endangerment, it was not for emotionally abusing the child, was not for yelling at the child. It was for physically abusing the child, for hitting the child. And the way that the prosecutor used this tape over and over in front of the jury was basically to show my client's propensity for violence, my client's propensity for hitting this child. It couldn't possibly have not affected the other counts. At one point, the prosecutor basically argues that it shows that he would have assaulted this child because he was so controlling, because you don't threaten corporal punishment unless you're going to carry it out. And he's talking about the assaults.
Why wasn't the father a party to the conversation once the mother answered the phone and left the line open?
In a lot of eavesdropping cases, that's a common factual scenario. I think it's Durham, and it was a lower court case, but basically 2 people are on a line, and someone else picks up a line and listens in. Well, they're on the line, but they're not a party to the case.
Well, that's not the case here. The case here was that the father placed the call. The mother, at least arguably, saw that the call was coming in and who it was from, since he had made several calls previously, and hit a button. Now, maybe she didn't intend to hit that button, but
right.
she opened the line. So once that happened, why wasn't he a party to that call?
The mother never realized she was opening that line, so she had no idea that he was a party to that call. And I mean, the people.
Is that the test, Counselor? That she had to know that she was a party?
No, I wouldn't say that that's the only test, but I would say that it's a pretty strong factor in this case. He was calling repeatedly, and she kept clicking off. And at one point she clicks the wrong button, and there he is, as if he picked up a line.
Well, what bothers me is that, here you have a situation where somebody makes a call. He didn't do anything affirmatively to gain access to overhearing this conversation. He placed a call because he wanted to talk to her. Somehow the line gets open and he hears it. So, and he hears somebody yelling at his child. What is a person supposed to do? What concerns me is that in this situation, that person then may be subject to criminal liability under the statute. I mean, here we're just talking about whether it's admissible. I understand that.
Right.
But in order for it to be inadmissible, it has to be criminal under the penal law. So I'm concerned with making that determination under this sort of circumstance.
I think it's important, what he did do and what he did say. I mean, basically, he heard his child being yelled at, which was not a charged crime here, and he did nothing with the tape.
Well, I'm not talking about the vicarious liability issue. I'm just
Right.
talking about assuming it wasn't a child. There was no child involved. This person places a phone call. Mm-hmm. The phone gets answered, and he hears something.
Right. Okay,
That makes him criminally liable for overhearing that conversation, whether or not the person who answered it intended to.
I hear what you're saying, and this is kind of the problem I have with that. If I'm standing up here and I say to you all, my heart is beating not just because I'm nervous, but because I'm having a heart attack, what I would really respectfully not want you to do is pull out your cell phones and press record. I mean, if you really think that there's a problem, if you really think there's a crime being committed, probably pressing record on your cell phone isn't going to, and if you have an obligation to do something about that, I don't think that pressing record on your cell phone.
But in your example, you would welcome the act of someone, not the recording part of this, of going and getting help.
Going and getting help.
Under this example,
Sure.
The recording, in a sense, is a way to ensure that the people on the other side don't deny the bad conduct, because your example is not about bad conduct or potentially criminal liability.
But yeah, I think the analogy is still apt, and it works both ways. I mean, that's fine. Even if we want to record it for what? What he recorded it for was to be used in court. He never did anything with it. So what was he recording it for?
Well, is that your argument that if he'd called 911, then it would have been okay?
No. What he should have done, perhaps, if he really was in fear for his child, which he wasn't because he testified he wasn't, but if he was in fear for his child, what he should have done is called 911.
And that would have been okay, and if the...
No, this
let me
tape
finish
still,
my thought.
no.
Let me finish my thought. He would have called 911. The person would have been arrested. This is the next case. The person gets arrested for beating up a kid, and he moves to suppress because the probable cause is based on a violation of his rights under the eavesdropping statute, and so they dismiss the case. Right?
Without any recording.
Right.
Judge Pickett asks tough questions.
He does ask me
does.
tough
Counsel,
questions.
counsel, if
guess
the
you have
child,
Thank you.
if the child were 21 years old, would the child have had the right to click on the recorder on their cell phone and record that conversation in that house?
Yes. Yes, if the child was 21 and it was a conversation between the child and the mother or the child and the mother's boyfriend and he wants to record it, yes. Yes.
He's present.
Because he's present, yes.
So the judge's point then is that, so why wouldn't the parent be able to step in and have the same right?
That would be vicarious consent.
Right.
I know. And I did so much research on it, and it's a great issue.
I have to.
But it's not the issue in this case because it wasn't preserved. It wasn't litigated at trial. That issue was not litigated at
The
trial.
court made a finding of that, made a determination of that.
No, respectfully, I disagree. The court did not find that there was a vicarious consent
Well, it
exception.
didn't use those words, but
No, and it did not use any words that suggested that under New York law there is a vicarious consent exception. It did not use any words to suggest that this case would fall into such an exemption. And it specifically did not make the determination that the Pollock threshold was met. In fact, if it had known.
The court didn't say, here the people sufficiently demonstrated that the father had a good faith, objectively reasonable basis to believe that it was necessary for the welfare of the infant to record the conversation such that he could consent to the recording on the infant's behalf?
Is that the trial court?
It's the appellate division.
Right. I'm talking about the trial court.
Oh, well.
This is waived in the trial court. The trial court, in fact, said to defense attorney, I'm going to let this in, but here's good news. You have a great avenue of cross-examination because anybody would expect a father hearing this to have done something. So, again, that defeats Pollock. That defeats the Pollock threshold. The court didn't know there was a Pollock threshold because it wasn't ruling under Pollock. This was not a vicarious consent case. It wasn't a vicarious consent exemption case. If I had gotten into an elevator with the judge and the defense attorney and the prosecutor after this case was over and said, hey, I heard about your vicarious consent exemption case, they would have looked at me like I was crazy. I would have said, hey, how did you get around the Pollock threshold? They would have had no idea what I was talking about. So that's the elevator, waiver standard. But this wasn't litigated at trial. Reading an exemption into a statute is a pretty momentous kind of thing to do.
Counsel, let's assume for the sake of argument that the issue was preserved. Can a vicarious consent exemption be narrowly drawn on the facts of this case before it?
Absolutely not. Absolutely not. And, I walked through in my brief the difference between this case and something like Pollock. I mean, first of all, I would say that the legislature didn't put in an exception because it didn't want to. And here in New York, we have pretty strongly worded opinions, Burke, that says there's other ways we can protect our children. But even if the legislature had put in an exemption under these facts, no, because these facts are different. This conversation is by the non-custodial parent, and it's taking place in the custodial home. So not only is somebody putting something on the phone in their home or recording what their child is saying in their home, this is somebody coming into my home and recording what I'm saying in my home to my child. That's very, very different, and it really takes it out of the...
Yes, but this person didn't come into your home. This person was let into your home because you answered the phone. Again, intentionally or not.
Well, or one of my kids left the phone off the hook, or I knocked the phone over. I accidentally, without realizing it, all of a sudden, I'm not very technologically savvy. So maybe I open something on my computer. And maybe I do that. But I don't mean for somebody to spy on me through it.
Well, I thought you were making a little bit of well, at the beginning, I thought you were making what sounded like your stronger argument, which is...
Oh, good.
which is, it's not by mistake. She's intentionally trying to disconnect. The fact that
Well,
she
she
may have a technological challenge, and perhaps I would
Right.
have one too.
Right. Okay.
That's what it's. She is not at all inviting this. She is trying to stop this. I thought that was
Thank
the
you,
argument you were
Judge.
making.
Exactly.
But would it make a
that's
difference under Judge Stein's idea behind Judge Stein's questioning, as I understand it, that this really, at best, at worst, was an accident, right? I mean, the husband or the person who's listening didn't call in the father thinking that she's going to leave the phone off the hook and I'll hear something. He calls in, whatever happens, the mic is open. Would that be different than somebody putting something on your computer so when you open an email, they can start listening to your conversations? Would your analysis be different?
Maybe, but what I was saying is I think there are things on computers now where, I don't know, FaceTime and stuff like that, where somebody didn't necessarily put it on, but somehow, because I don't know what I'm doing, I leave it open, and somebody...
But would it be different if somebody put a bug in an email, and which I don't know if this is possible, but would enable you to eavesdrop?
That
and
would
did
be-
it intentionally.
That would be bad. But he did intentionally push
It would be
record.
bad, but would it make a difference to the analysis of whether or not this is a problem?
I don't think so, because again, he starts listening, and instead of doing something, he pushes record, and that is
So it's
intentional.
record that makes this a violation?
There's so many, it's on so many levels, but again, as a factor, I think yes, and pushing record does make it.
Well, they're the same case, really. It's just, perhaps you get to that point from a different spot, but it's the same case, because your argument is he's intentionally chosen to record.
Yes.
Maybe that's not where he started.
Yes.
But at the point in time it matters, that is, at the point when he's recording, that is the phone call, perhaps there's no interest at that point, but the recording, which is what's at issue, is
Yes.
volitional, right?
Yes,
But
yes.
Is there any difference in any case where if you have a right, if you're on a party on a telephone call, you have a right to tape it, right? It's one-party consent. You can tape it.
Well, that goes back to the party.
Right, but why would it be different if the initial overhear is lawful in some way through whatever consent? Why is it different if he tapes it or not?
Because he wasn't a party. He wasn't a party to this conversation.
Yes, he was, and he's the one that made the call, and somebody else answered it. Now, suppose in the same situation, the television is on, and he overhears the theme song for Perry Mason. And the defendant in this case is making a claim that he was not there at the time of this incident, and this guy can testify, I heard him, it was 4 o'clock, because that's when Perry Mason comes on. Are you saying that you can't use that evidence because it was overheard on a telephone conversation?
If the person overhearing it who wants to testify wasn't a party to the
The
conversation, yes.
party, he's got the phone in his hands. I'm missing that. I get the mistake. You can make all the mistakes you want, but the fact of the matter is he's a party to this phone call that was made to this home.
No, I could have a spy cam in my hand, but that doesn't make me a party to the conversation that I'm illegally, listening in on.
That's a non sequitur, but I'll accept it.
Thank you, counsel.
Thank you.
Counsel?
May it please the court, my name is Jason Richards. I represent the respondent in this matter, the people of the state of New York.
Counselor, could you address the argument that defense counsel made that this wasn't preserved in the trial court, in essence, vicarious consent?
In fact, it was preserved. The judge, although perhaps not the most articulate, was clearly aware of the issue. He cited Clark. He used language that was similar to Clark in that in Clark, over and over again, it's emphasized that the child was present during the conversation, and that's something that this judge, this trial judge, said repeatedly in supporting his ruling. He also said that Clark was the only case he could find.
Just so we're clear, he cited it. I think it's in the appendix at 69. Is that correct?
Correct. Yes.
Okay, go ahead.
Yes. Correct. He also said shortly after he mentioned the name of the case that it was the only case that he could find on point, which means, and he said that it involved a similar issue. So I think.
Yeah, he didn't put the good faith exception in, but he did cite Clark.
He did cite Clark, and he said repeatedly that the child was present, that the father had a legal duty, which sounds quite a bit like the reasoning in Clark, which is that the parent is acting out of necessity for the welfare of his child. Although the language doesn't match up exactly, it's clear that he was aware of the issue and that he was relying on Clark, at least in part, in reaching his decision. And for that reason, it was preserved.
Is the father a party to this conversation?
The father is a party to, well, he's technically the sender of the telephonic communication that he recorded.
So he's not a party, he's just technically the sender?
If one artificially extracts something that's heard in the background and turns that into a conversation, that's the only way that he would not be a party to that conversation. But in that case, the conversation is still part of the telephonic communication, so it's still not eavesdropping if he records it. just as Judge Pickett.
If I have these don't happen as often as they used to, counsel, but if you have a party line, you know, do you remember that, where you're trying to make a call, but there are two other people already on the phone? Are you, if that were the case, would you be a party to that other conversation because you called and these two other people were talking on a party line?
Well, if your intention was not to overhear the conversation, the telephonic communication with, if you never intended to overhear someone, you just picked up the phone and accidentally heard it, I think that's the deciding factor, the lack of criminal intent here.
What if you stay on? You hear it, sounds good, I'm going to listen in for a while. Does that make a difference?
Well, in this case, the father heard his son being yelled at and threats of violence being directed at his 5-year-old son. I'm not sure.
Well, I understand the interest in listening to it. I just wanted to see what your response was to a slight tweaking of Judge Abdus Salam's hypothetical.
I think it matters how he got to that point, and I think that's implicit in one of the court's previous decisions that's relevant here. In Basilicato, the court ruled that the detectives who are listening in on a conversation had no prior, this is a quote, no prior justification for the intrusion, no legitimate reason for being present when they heard it. In this case, the father had such a justification, namely his innocent phone call. He called, the call was answered, and he immediately heard threats of violence directed at his son. It's implicit in...
Counsel, would you, just on that point, would you expect the father to do something other than just record the conversation? If he thought that there was something untoward going on in that household that implicated his son?
Well, the father was not on trial, but there are a lot of different responses that a responsible parent could make under those circumstances. One of them, I think, is to record the conversation if he's not sure what's happening and it sounds like there may be violence or threats of violence or references to past violence, and perhaps he didn't feel that it was his son was in imminent danger, but it was clear that his son was in some kind of trouble in this situation, and that recording the conversation would be in his son's best interest.
If we were to adopt a vicarious consent exception here, would we be opening up the door to sort of like a mini trial on whether there was a reasonable belief that it was in the best interest of the child, and you know, would we as a court, rather than, for example, the legislature, have to be, you know, kind of deciding where all these lines have to get drawn and what's enough? Is that something that we should be doing, and does it make sense?
It does make sense, and I don't think it adds a there are pretrial hearings on issues, Huntley issues, all the time to determine whether evidence is admissible.
Yes, but usually the evidence itself is based upon some legislative determination that's then being interpreted rather than having it created by the court.
Well, in this case, I don't think that this doctrine in any way contradicts the intent of the legislature, because when the eavesdropping statute was adopted, it included the term consent, which is a loaded term in the penal law and in the common law system, which we're part.
And it didn't say anything about an exception for children, right? The legislature didn't do that.
Not specifically, but given...
The legislature really didn't define consent at all in this particular statute.
Correct. And that's what I'm saying essentially, is that in using a term like that, they were importing these other understandings or from other parts of the law, including the penal law, and where it's clear that a child of a certain age isn't capable of consent. They're not capable of consenting to sexual acts. In fact, if they're younger than 13, they're not criminally liable. Excuse me.
But I believe we have said that they can consent to other things like being tape recorded. For example, in a case where they're trying to get an admission from an abuser or something like that.
Yes, that is correct. But this doctrine doesn't exclude the possibility that a minor can consent. It just allows a parent to vicariously consent under certain very specific circumstances, and it's a rigorous standard where the parent has to establish that he or she acted in good faith and that he or she had a reasonable basis to believe that it was in the best interest of his child to make that recording.
Could I ask you about the prosecutor asking for a jury charge on something that was not in the indictment?
Yes, of course.
How does that end up not being harmless? I just can't imagine. I can't imagine somebody doing it. I can't imagine a court allowing it, and I can't imagine saying, well, the jury, had other reasons to convict somebody. But it just seems so odd to me that somebody, because he had taken the stand. If he had not, if he chose to remain silent, it would have been one thing. But it's almost as if what he said on the stand in his own defense turned into it being used against him in this omission charge.
Well, in this case, from the record, it's not clear, but it appears that somehow this issue came up, whether the court itself brought it up or the prosecutor did. It was charged, and it shouldn't have been charged. However, there wasn't one scintilla of evidence at trial, whether from defendant's testimony or from anything the prosecution put on or anything else in the defendant's case that would have supported that uncharged theory. And for that reason, it was harmless. According to the defendant, he had no idea that this assault was taking place.
Well, yes, but there was a lot of testimony, and I'm not sure what the purpose of it was other than to show that his involvement as a parental figure for this child. There certainly was evidence that he knew about these injuries to the child, and he didn't take the child for treatment or anything like that, even if it was just after the fact. And other evidence that he knew that the mother had been doing these things in the past. So I don't know how you can say there's no evidence. And if there's no evidence to support that theory, how could there be proof to support an aiding and abetting theory?
There was no evidence to support the idea that he was consciously aware that this was happening and took no action with the criminal intent that the mother.
Well, then how did it end up in somebody's mind that it ought to be charged? I would have thought otherwise it's not here. We don't charge it. And then the judge says you can convict him on any one of three theories, and this happened to be one.
I can't answer that question. I can say, however, that there was no evidence that supported the theory. There was no rational view of the evidence that would have supported a finding of guilt on that theory. The evidence that was presented at trial didn't vary from what was in the indictment.
Well, one of the concerns I have, and maybe you've experienced this, maybe you haven't. If you win a case in the appellate division, the trial lawyers, it's his win or her win. If you lose one, it's your loss. It's not his or hers. You understand what I'm saying? You lost. They won the case below, and you lost it in the appellate division. I worry that if we don't do something about this, that DAs or prosecutors can say, well, we can amend an indictment anytime up to the jury charge or up to the summation, even after the defendant has testified and left the stand. The only thing the court said was that in this case it was a mistake, but it was harmless.
I think this is not the case for that. I think this is a very unusual case, and I think that the appellate division's ruling already makes very clear that this was error. We're conceding that
And
was error.
candidly, you did, which is to your great credit, I know. Yeah.
But it's an unusual case in that there wasn't, it's like Grega, this court's precedent, in which there was no evidence supporting the uncharged theory, and for that reason it was a harmless error. I think that the decision on its own gives proper guidance to prosecutors, and it would be, in a case like this where there's no evidence supporting the uncharged theory, it's not the right case to send that message.
I have one more question about the eavesdropping. What was the purpose for admitting that recording in evidence?
To prove the endangering the welfare of a child count, which covered the time period.
Based on the threats?
The threats of violence, the admissions of past violence, it sounds like it's leading up to.
So you're saying that the endangering, okay, but the endangering was based on acts of violence?
Yes, yes, and that wasn't the only proof of that. There was also proof from the landlady that she heard other beatings during this relevant time period. There was also proof from the teacher that the child was absent after one of those beatings for several days. And there was proof from the father that that the child was, part of it was stricken, but he did learn from the child that physical punishment was being inflicted upon his son.
Thank you, counsel.
Thank you.